So even throughout the process paive manesi or vanhu vaiuya vachindibvunza vachidi, you could see kuti vanhu vaingouyawo not really kuti vabatsire or kunzwa kuti nini ndiri kufungei nezvaiitika. Kusvika vamwe nesi vazonditi hauna here a family member. Ndikati family members they can come. So pakauya ma-family members angu akauyawo they had their own narrative. Since ndanga ndangoita nhumbu nemunhu tanga tisingagari tese but we together. Vangoti avangosvika I don't know kuti vakanyatsa kutsanangura. I think vanenge vangoti akamitiswa murume wacho akatotiza nemukono kuti haapo panapa mwana ingopisai mwana. So the following day pandakazodaidza vamwe nesi in charge ndakaudzwa kuti zviri kufamba sei, baba vacho vati is okay mwana anogona kusara kuchipatara wopiswa, asi vati vari kuuya mangwana so that tisaine mapapers because ndandaudzwa kuti mapapers anosainwa namai nababa vokonsenda kuti mwana anofanira kuitwa sei. Vakatonditi hama dzako dzatotaura zvavatotaura everything wakutofanira kunonzi kuita sei, vatosaina kuti unofanira mwana ngaapiswe nekuti baba vacho havapo vakatotiza and everything. So I tried kuti ndiende kuti ndinoona mupurisa because pane paine mapolice foot involved, ndivatsanangure kuti what was really happening on the ground. Apa ndandabva kusununguka kwaye ndaifanira kuenda kwacho, it was a very far distance echinge kakure kuti ndifamba, handisi kukwanisa kufamba, hapana munhu ari kukwanisa kundipusha pawheelchair. The moment ndakazokwanisa kusvika ipapo kwati everything zvatoitwa, handiti wakamitiswa here iwewe. Saka handisina any say pazvinhu zvandaifanira kunge kuti ndisikewo just nditaure my own side of the story, zvekuti even pakazoya baba vacho everything zvatosainwa ndasina changu ndakazongotakura mabhegi angu ndobva ndatongoenda kumba. Saka this is the situation andoona inosangana nemadzimai vakaremara kazhinji kuti pavanoda kusika justice vanhu vanenge vatodecida zvavanenge vatodecida on their behalf, vanhu vatovajaja, and sometimes vanhu vakangoona munhu ane disability vanokufunga maybe hakwanisi kuzvifungira ega kuti akwanisi kuzviitira madecision ake. And also the issue yekuti accessibility chaiyo kuti pamwe ukaoda kunomhangara kwacho hausi kukwanisa kusvika, une wheelchair une chii. So ndo among ma-issues atiri kusangana nawo semadzimai akaremara pakuaccessa justice. Thank you.
Yes, we can clap hands. All right, thank you Sinikiwe for that. Sinikiwe is sharing her issue that some time back she had a child before she was married to her husband. And unfortunately this was a stillbirth, and then they needed to work on the papers, I think between the hospital and the police, in order to ban the child who had come out from the stillbirth. So she was highlighting the challenges that she faced as a woman with disability. She says in terms of accessibility, you know, the places, be it the police station, the hospitals where she had been to, they really don't cater for women with disabilities or any other person with disability. There is also the issue of stigma and discrimination that comes out as she is trying to get assistance from public offices. So Sinikiwe, thank you for sharing that and for highlighting those gaps. At this moment, please allow me to call upon Samantha Mushore. Samantha is from Deaf Zimbabwe Trust. She will give an overview of the challenges that women or persons with disabilities face in accessing justice.
Good morning to you all. Thank you so much for this platform. So I am from Deaf Zimbabwe Trust, like she said, and I am a legal officer there under the Disability Rights Law Center. So firstly, I would like to commend our justice system for the progress that is happening in our justice system. So as Deaf Zimbabwe Trust, we worked with the VFS, the Victim Friendly System, to actually come up with what we call the disability identification stickers, where we say that the initial problem is at the police stations. When persons with disabilities or women and girls with disabilities go to report, their case is noted down, but then when it goes to court, there is no identification that this person has such a disability and they actually need reasonable accommodation. So the stickers would work in the sense that if it's a deaf woman who has reported the case, there's a sticker showing an ear that is placed on the docket. When it goes to court, they will know that this person needs a sign language interpreter. So after our funding went, still the victim-friendly system is still continuing with the disability identification stickers. We also thank them from the victim-friendly courts, very responsive. When we have a case and there's need for reasonable accommodation, you can easily get a hold of them and they assist promptly. There's also an improvement in sign language interpretation in courts and at police stations. When I started working in 2022, there was one sign language interpreter nationally. But now there are actually, I think, more than 15 or 20, I'm not sure of the number. And they're still training more interpreters. So that is actually well done. And it improves justice for women who are deaf and girls who are deaf. I would also like to note that I want to thank Mem Tombeni. Maybe she doesn't know anymore, but we had a case where we had a girl who was sexually violated, and the person was in the village. She did not have any formal sign language, so even if you come with a sign language interpreter, she can't say anything. So what we did is that we asked for her to say, please, she actually called us and said, this case has been here for 3 years. Please, can you do something? So she allowed us to devise a way where we could try to interpret for the girl who is deaf and has no sign language. We put a person who is deaf with formal sign language. Then we put a sign language interpreter who is hearing. So we played that in court. We used pictures, and they were very patient in the court. And for that shows that there is the will to actually provide justice for women and girls with disabilities. So I would like to thank our justice system for that. However, there are still challenges, and I think most of them have been shared, where we talk about financial challenges. Women and girls face, if we say women are at the bottom, then women with disabilities would be very much disadvantaged. So they face challenges of financial assistance when they report cases. They have to work with an aide. They will need transport. And you heard where she was saying that you are then asked that go and find the person that they want to track. So you need to go find them. That's also a financial burden on the victim. So those challenges are there. They also don't have enough access to legal aid or legal education in general. They lack empowerment to report. So in some cases, the perpetrators can actually be the guardians or the family members who are taking care of them. So in that instance, that knowledge of how do I then report this? Or a case where it's reported, but you actually consult them and you talk to them, but they can't say anything because the person you've asked to assist you in interpreting or being with them as an emotional support system is the perpetrator. So those are some of the challenges that women and girls with disabilities face. Some are then married off after being raped. The perpetrator will just say, I'll give you a cow. And the family agrees because to them, this girl or this woman, a cow is good enough, right? So these are challenges that they are facing. And also a challenge to note is that there is a high increase in women and girls with intellectual disabilities that are being sexually violated. We went to Bindura and we were hearing stories of how women with disabilities are being said to be lucky charms for farmers who farm tobacco. So they say that they actually roam around and say, okay, there's a girl with an intellectual disability. Once you leave them, because the guardians sometimes need to go and work and make money, that is what happens. And they leave them alone. That man will simply go, because already there's been a target, and they believe that sleeping with them actually brings them more luck and they will have a bumper harvest. So that is why there has also been an increase in their cases. So the opportunities that we have is that we can do legal awareness for women and girls with disabilities, talk to them in our different communities where we're working, or also legal aid outreach. LRF does that, and I'm very happy for the work that they're doing. We get testimonies of their assistance. There's an opportunity for us to use technology in digital justice, virtual hearings, online complaint systems, SMSs, so that we reduce the transport barrier that is there. Also, having the DNA is important for women and girls with intellectual disabilities who might not be able to really defend themselves when the perpetrator is found. Thank you.
Samantha, thank you. Another round of applause for Samantha. Yes, thank you even for highlighting the positive changes that have been happening within our justice delivery system. We really needed that. Thank you. At this point, allow me to introduce to you Dr. Mildred Mushunje. She is the director of the SRHR Africa Trust, but she's coming in representing the Women's Coalition of Zimbabwe. Dr. Mshunje, over to you.
Thank you so much, Bianca, and good morning, everyone. As Bianca has indicated, I'm from SRH Africa Trust, but I'm here representing the Women's Coalition of Zimbabwe, specifically the GBV cluster. Very interesting conversations happening, and thank you so much to our sisters for sharing those heart-wrenching stories. I think it takes a lot of courage to just come up here and talk about this story. And I hope that as part of this process, we'll be able to engage in the referral system and ensure that things are brought to conclusion one way or another. I think in summary, just listening to the conversations, my task is really to reflect on what was being presented. And from where I sit and where I was listening, and as I was trying to figure out how to summarize, I think in short, what I can say is that women and girls in Zimbabwe, and more so with disabilities, they face layered barriers, in everything that they do. And I've decided that I will just highlight these barriers maybe into 4: the social, economic, institutional, and physical. Those that they severely limit their access to justice. And for a number of reasons, I think you'll find that when these come into play, it's very difficult for women and girls to access justice. So the first one, looking at issues to the barriers, the attitudinal barriers. I think some of you alluded to this, but things to do with, being perceived as a woman with less capacity or capabilities than any other. And it's worse for a woman with a disability. So if you go to, if you're going to seek a service, because you have some kind of disability, it's assumed maybe even intellectually you are not able to make decisions. And I can give examples of things to do with access to reproductive health. We had instances, I think a while back, where women with disabilities would be summarily sterilized, without their consent. Even access to justice around agency, around reproductive health, if one wants to have a termination, that also becomes an issue. So the right to self-determination is very limited for women and girls, and more so for those with disabilities. And I think you already talked about the discriminatory practices in courts, police, the justice system, community leaders even, they tend to dismiss or minimize complaints that are brought to them. You also talked about issues to do with access to finance. If you have been, you have experienced GBV, and you're a woman with living with a disability or with a disability, I think that the layered injustice is very evident here, where you are required to then be the one to find the money to transport a police officer. It's difficult enough for a woman who doesn't have a disability, but more so, I think, because of the double discrimination, that also then becomes even more difficult. And then issues to do with physical and communication barriers, that has been highlighted already. Issues of inaccessible infrastructure. We've heard of the very sophisticated system that has been introduced in our courts. So if you want fair and equitable access to justice, that court system is very difficult to navigate, even for me, with visual, with hearing senses. I shudder to even navigate that online system. So it becomes very difficult to access, things like sign language, interpretation, braille material, technology itself. Yeah, you are expected. I think one of our sisters here was talking about access to a cell phone, access to a smartphone. Some things that we take for granted, but it can be a life-transforming gadget for somebody. And if they don't have access to it, it means that even taking the case that they've brought forward for justice is also compromised. And then there are also limited services that speak specifically to women in general, but I think even more so for women with disabilities, especially when you look at the number of trained personnel that we have. I look at medical doctors, I look at social workers, I look at legal practitioners, anybody who gives out a service. To what extent are they sufficiently trained to be able to interact and give the necessary service, which would then facilitate the path to access to justice? Then the economic challenges, I think those have already been highlighted. Issues to do with high cost of justice. It's very difficult. Transport. There was a case that happened in Mutare, and it involved me. And when the police was calling and they were saying that they wanted me to be a witness, I said I don't have the money to come to Mutare and be a witness, And for sure, I figured that if I start doing this, it means each time the case is being heard in court, I would be required to foot my own bill. So I stood my ground and I said, I don't have the money. But imagine if it's a case that is to my benefit. This one, it was for the state. I was going to be a state witness. But imagine if it's a case that I'm invested in and I want to be there, and you are being asked, one, to find the resources, to find the money to attend court. You are being asked to find the money to bring the witnesses to court. I've even heard police officers saying, go and find the perpetrator. Go and bring the perpetrator. How do you do that? And I think the legal officer from Deaf Women Zimbabwe gave us some suggestions around how to address some of those issues. And then the dependence on caregivers, especially for women with disabilities. If we are here in this room, if somebody is hard of hearing or visually impaired, it means we require them to have an assistant, and often we don't want to invest in that. So when you want to access justice, the cost of having an assistant. The cost of having an assistant just to be with you, whether it's in the community, whether it's as you travel to access the justice, can also be very prohibitive. Yeah, and then issues to do with stigma. We have a culture of silencing survivors of GBV to the extent that they then don't access justice. Some think it's shameful that you have experienced GBV, so they don't want to report. They don't want to speak out, and as a result, we perpetuate the culture of silence. We perpetuate the stigma associated with women experiencing violence to the extent that they shy away from accessing justice. Even when it's a clear case where somebody would be, is liable for reporting and they can get justice. At times they don't do that because of the stigma associated. And then, of course, I think we've heard this from our speakers, from our presenters, issues to do with the legal aspects. We are a signatory to the Convention on the Rights of Persons with Disabilities, but in terms of implementing the various laws, the various policies, and even the Convention on the Elimination of All Forms of Discrimination Against Women, so those international, regional, and even the national policies, conventions, laws, and so on, they are insufficiently implemented. And as a result, we find that women and girls will continue to suffer as they try to access justice, and it becomes worse for those with disabilities. So the layered barriers to justice are very prohibitive, and they work against us. And I'm so glad that we're having this Indaba and that we're crafting some possible solutions to this. I hope I've reflected fairly and sufficiently whatever. Charamba chirungu.
Thank you, Doc. Thank you so much for those reflections and, for just wrapping up, these experiences that women and girls are facing in accessing justice. I also want to thank our panelists, these 5 beautiful women, and for agreeing, to share your stories and to just help us in this Indaba. Apologies, I think because of time constraints, I won't allow any questions directly to the panel, so allow me to, yes, I think you can take your seats. Thank you so much. So as they are taking their seats, we have a legal expert in the house, Advocate Mandinde. He's the director of the Zimbabwe Human Rights NGO Forum. He wants to just respond quickly to the issues that these women were raising and maybe just come up with recommendations after this session. So this is the concluding part of this session. Over to you, Advocate Mandinde.
Thank you, Bianca, and a big thank you to the women who shared their experiences. In the course of my practice, I have come across these stories. Vatosiya dzimwe nyaya, and pane one andinogara ndisangana nayo issue yekuti matrimonial home inochongochengetedzwa kazhinji kacho, other than in circumstances dzine will. For example, my examples atapiwa na director. But pasina will pamatrimonial home, aiwa amai munoita sei munoiwana kana kunzi ndimi ani ndimi amai. And then it is the other properties where you are then expected to get a child share. But I once dealt with a brief way. Baba vafa vaine vana vavo 4 kumba, kwakazowanikwa kuine vamwe 4 kunze vanenge vasingazivikanwi. Apa baba vaive netumaproperty twakati, I think there were about 4 or 5 other houses, and vaya 4 vakubva vauyawo manje vakuda nhaka yani yababa vavo. Apa mukadzi uyo ari kuti but ini nababa tisu tanga tichiita sei tikishanda, isu tiri kungoti imi munotora chi matrimonial home. Pane dzimwe dzese idzi mava kudya inonzi child share. Saka pawanga uchifunga kuti ndiri kudya nevana vangu tiri 5, maakudya muri chi muri 9. That's basically what it becomes like in terms of the law. So a few recommendations that I think I will give. The first issue, Madam Director, which I want you to contemplate. It's an issue which just came to me ndakagara apa when I listened to the presentations. Isusu marriages edu muno are out of community of property. Chako nde chako, changu nde changu. That's out of community of property and it. As tikango cross a border when South Africa are in community of property. Why is it that our law is like that? And what does it take to change our law to have our marriages regime being in community of property? Because if they are in community of property, then to see an aspect so that's the first issue, and possibly an assignment I would request my host to see. Let's consider this as an advocacy issue to say, why can't we have our marriages move more towards in community of property? Because I think that would be advantageous. The second issue is, at the moment, as lawyers, we very much encourage the aspect of trust registrations. Semadzimai, what can you do to push anababa kuti ngati register ichi trust? Ngati donate ma property yakuti ku trust. Those issues will then make it easier for managing, because baba vakafa, trust haina kuita sei, haina kufa. Trust is a perpetual existence. Trust inoramba ichienderera mberi. Zvinhu zvinosara zviri mutrust. Trust anenge afa ndiye anofa. Otoreplaced but odrafta matrust aya tinenge takatoita maprovisions ekuti unoreplaced sei mutrust ukaita sei ukafa, but haisitombo issue inotomboenda kana kwamaster. I hope kwamaster havapo, because ndogara ndichitaura kuti patrust tiri kusevha ka 4%, ka 4% ke estate value aka ndokanenge ifanira kuenda kupi kwamaster. Hakaende kana iri mutrust, because trust haina kuita sei, haina kufa. Master vanodhila nevachakabvu, trust haisi muchakabvu. So let's try to encourage those things, because anababa tiri kufa kazhinji handiti muna anababa tisitones totanga kufa. So but nofa paya handiti munosara futi musina 4% yacho. I was having a discussion like about 2-3 days ago. Ndakapoendwa through special power of attorney kuti ndibatsire executor pa estate. And the first issue I noted is pane imba iri worth more than $200,000. And master vanofanira kubhadharwa mutero 4% of estate value. So I was asking guys, 10,000 kuiwana papi apa kuti tigoita sei tigobhadhara estate value. And mutemo wacho unoti kana tashaya kwekuiwana ndeifanira kutengesa imba iyo kuti ndobhadhare chi muteroyo, because master vanofanira kuti vaite sei vabhadharwe. So let's be very deliberate and serious about thinking about some of the issues such as matrust, because tinosiyira vana vacho nhamo, tinovasiya vasina nechinhu. Then the third issue I wanted to talk of, pane issue yataurwa yemamarriages. Hapana munhu asingarambike, mazvinzwa, aripo nyange asipo haite sei, hapana asingarapike. Inini ndonyanya kuda ende ndoona anyanya kudhila nawo vanonzi havapo hatisi kuvawana, tovaramba vasipo, mazvinzwa. And I also said, I think you are here as part of the issues that you might want to identify for continuous professional development. The issue of substituted service is real. Let's just do the application for substituted service. To recommend if I get a brief like that, I can say Zimbabwe. I think boy some newspaper no very nevan. Tosa garsinga very nevan. But Matthias advert yacho to no one default judgment. Oto mramba. 5 years later, unengo ifunga out unemere certificate yo akaramba. Saka Musa achike kutizo avatswanikwa avazoti vasingawanikwe ndo arito easy kuramba because avaite nharo. And I think those were some of the issues that I thought musaore moyo madzimai. And it's look side kwenyu. Normally I'm called the devil's advocate because ndenge ndakambira nevarume tichaura nyaya idzi kuvarume, but I want to side kwenyu, and please take this advice seriously. Thank you, Bianca, for giving me the opportunity.
to appreciate our facilitators and also just to thank our colleagues for the recommendations that we received. Let's give them a round of applause, please. Uyezve toda kungotsinira nekutenda madzimai auya akataura. These are real life issues. These are very tangible issues. I would also love to emphasize that these issues are not synonymous to social status. There are two cases that are part of Zataura and Madzimaya that I have actually linked to myself. And I'm going to consult further regarding some things that I can even get legal recourse for this. We just want to thank you as well for this platform. Thank you very much. For the longest time, I've had a lot of consultations. I work on radio. I've had lots of, you know how everyone assumes that, or most people assume that I can order radio. Say, and we've always just recommended. And I was wala mama. And I was wala pane varipo wanguna kukubatsirai. Asuka zogara pasuka nzwangu wachitaura kuti kunyai inini kusaziva cheteka. Ingoro ignorance, zvinowanikwa. I can also get legal recourse. Very, very beneficial. We are also going to open the floor at some point for us to have this discussion. Kuti tinzwe zvakare kuna mazvikokota vanenge vachinzwisisa kuti tinofamba sei, tinodzigadzirisa sei nawedzi. But ladies, I want to thank you. Sinikiwe, you are amazing. You are amazing. What is our son's name? Today Rwanga achitaka pasi petable kudai. Vapi wa banana rake tadairwa tikafunga tachatendera nekumasters akati munonyepa. Pasi petable pake zvakare. A happy boy, but such a brave mother. And tudongotenda ana maduve dakutenda soko for having a very clear voice. Pasi patinotaura tokumbura kunzwikwa. Tikasanzwikwa tongoramba tichisangana tichitaura nyaya idzi zvisina zvasiri kubatsira. Ndinotenda our legislators are here. So nyaya idzi tinokumbirawo kuti tinzwikwe. Tinokumbirawo kuti tinzwikwe. Thank you so much. Thank you so much, Doc. Patinotaura tinokumbirawo kuti tinzwikwe. One more time, round of applause for Bianca Maere and Wadzanai Wami. And again, thank you so much for opening up the floor so that we may have these discussions. All right, we're going to get into another session. And right now, we are going to talk about interrogating justice systems and the lived experiences of women and girls. Interrogating justice systems and the lived experiences of women and girls. I'm going to be very tough on our time here because we have got our panelists who are going to come through to chat after a plenary session. So I'm going to ndasumuka mozadi ndasumuka ndingoti nguva so that bafambirana zvakanaka. We don't want us to take too much time. And so it is an absolute honor to welcome to the podium Abigail Machai, I beg your pardon, Abigail Machai. Let's give Abigail a round of applause. Executive Director, Zimbabwe Women Lawyers Association. And Abigail has got a panel that is going to join her for this discussion. Thank you.
Thank you very much, Director of Ceremonies. Good morning, everyone. Good morning. Thank you. Much, much better. I'm going to speak about some of the challenges. Many of them we've already heard from the panel that came before me, talking about the lived realities for women and girls in the country. I think the starting point, as they try to connect the slides, the starting point is really just to acknowledge the progress that has been made. And I think in the morning sessions, as we heard the presentations from the Permanent Secretary and the Minister of Women's Affairs representative, the laws are there. And that's one thing that we certainly celebrate as a country. We have made progress in that regard. The conversation we are having now is to reflect the translation of those laws into reality. That is where the issue is. When we talk access to justice, we are talking about the translation of these great laws that we have into actual reality, and reflecting on where are the gaps, what more is needed to ensure that we make progress. Sorry about that. The connection seems to be a challenge. So the reflections that we are having are now saying, how do we bridge that gap? What are the things perhaps we need to invest in? Looking at the laws themselves, are they adequate? Are the structures that are there to implement the laws adequate? Where are the gaps still existing? So that's really the conversation that we are going to have. And I'll present that, amplifying some of the things that have been said already. Technology seems to be doing things today, but I will continue as they try and bring up the slides. So the reflections that we want to talk about, I think the first issue is just in terms of the limited access to the courts that we have. And that's a barrier that is there when we talk about access to justice. When we are reflecting from a point of view of women, and in particular survivors of gender-based violence, we've got to ask which are the relevant courts that are mandated to deal with this. And therein lies the barriers for survivors of violence. When we talk about sexual violence, most of the sexual violence cases go to the regional court. Go to the regional court. The regional courts that we have in the country are not that many to be able to resolve the issues of sexual violence that we have. I had a nice slide that was going to show you how many courts we have, but nevertheless, since the slides are not coming up, I will just speak to the issues. When we are looking at our magistrates' court, by and large in the country, we've got under 60 magistrates court, 56 thereabout. Within those 56, there's a specialized court called the regional court, which perhaps is half of that number. So when you are talking about a survivor who has been raped and has to access this court, it's now a matter of where are you located for you to be able to enjoy your right that is already protected by law. In terms of the Judicial Service Commission that designates these courts, the call that we have in that regard is, can we have more courts? For someone to travel, a rape survivor, to travel over 100 kilometers to be able to access the next or the nearest regional court, for that matter to go into court, to be able to travel that particular distance with witnesses, to be able to stay the course as the matter proceeds within the court, presents challenges for many. Some abandon their cases simply in terms of, where am I located? Can I even find myself in court simply because of distance? The same applies not just to the courts itself, but in terms of access to police stations. You still have travel gaps that are there, people still needing to travel long distances to be able to access these services. It's okay. To be able to access these services. So the lack of infrastructure that's close to people continues to provide barriers. If you have to travel, if you imagine someone who has been raped, we want to preserve evidence, and this person has to travel 30 kilometers in Caesar, for instance, you travel 20 kilometers to your nearest police station. You've been raped there, and you have to travel for the police to be able to gather whatever evidence that is required of you to be able to pursue that case. Beyond your travel distance to the police, you now have to travel to find your nearest regional magistrates court, which is not necessarily close to where you are residing. So these issues tend to compound and at times really leave survivors of sexual gender-based violence in particular left on the margins, because when they think about what it entails, having traveled that distance, court is not going to be finalized in a day. You are going to need somewhere to stay the course as the court goes on. Now you've traveled out of your area of residence. The court is going to say, take for instance, say on a good day, 3-4 court sessions. You have to find somewhere to reside, you and the witnesses, for you to just pursue that case to finality. So sometimes these things tend to just really deflate survivors from pursuing justice. So I think the point in terms of the limited coverage of services continues to be a barrier. Moving forward from that, you also find the lack of access to representation or legal aid as another barrier. Legal aid that has been spoken to, and we celebrate, I think, and acknowledge the position taken in the presentation by the Permanent Secretary of Justice that there is an expansion program that is currently underway. Legal Aid Directorate, which is the government-led legal assistance, has expanded its services, but it continues to be limited, particularly when you talk about district coverage. The coverage is mostly in the provinces, where people are found in the districts. These offenses are happening at district level, but access to the legal aid services is perhaps mostly in your provincial areas. So when we talk about the decentralization, it becomes a key issue, because navigating the justice system, if you are not familiar with it, if you do not have money for lawyers, it becomes a total nightmare. And sometimes just that becomes a barrier to justice. Beyond the Legal Aid Directorate, you also have CSOs that are providing legal services, many that are represented in this room. At one point in a consortium of access to justice partners, we were covering more than 35 magistrates' court of these 56 that I'm talking about, providing services at what are called help desks, which are help centers at the courts. That coverage has totally shrunk due to limited resources. So when we talk about where are these services, you will find that they are only dotted in as far as each institution can cover. And what we are having is infrastructure that has been built by the JSC that has provisions for help centers. But what don't they have? The people to man them. The people who are able to provide services for litigants, particularly self-actors, who need to navigate the justice system. So many of these courts that we are talking about, help centers are only there in as far as the structure and form, but the actual service provision is not there. And the challenge really being the lack of resources. So again, when we hear the ring fencing of resources, the commitment to ring fence resources for access to service, it becomes a very welcome gesture. We also have interventions like one-stop centers. On this point, I'm simply talking about what are the points where you can access legal support. You can get legal support from the government legal aid, which at the moment is mostly at provincial level. They have started district expansion, but very limited districts are covered. You can get access to legal aid services if you're an indigent person from CSOs that provide these services. But even them have either been hit by COVID or the limited resources floating around in terms of supporting these centers. So we've seen shrinkage in terms of those services. You can also get specialized services from one-stop centers. One-stop centers are specifically trying to target survivors of sexual gender-based violence, where you have an integration of services. support services like counseling services, you've got the police there, you've got health services offered by the hospital because these one-stop centers are based at hospitals. And then you also have legal support services. If you look at these centers, starting from coverage, these centers are not covering the 10 provinces. We haven't even spoken about districts. The ones that are covering the 7 provinces, they are not functional to effect because they do not have resources. If you look at 2025, many of these centers were actually closed. So when we talk about the need for financial resources to support access to these services, these are the issues that we'll be talking about. We also have cost barriers beyond the legal aid work that is done. Cost barriers are really the costs that are related to enforcing your right. We've heard some of those costs from the panel that we had before, talking about what are some of the costs that are involved. But just to add in terms of that, if you are someone who is staying in a marginalized community, you are going to need to fund your transport to and fro the court structure. You are going to need resources to be able to support the witnesses. There are witness expenses that are provided, but I think in the panel we'll hear more in terms of, are these witness expenses real and are they going to where they must go? So costs remain another big barrier in terms of accessing services, particularly when you think gender-based violence. The reason I continue to defer to gender-based violence is because by nature of the offense or the issue that we're dealing with, you are going to need a number of services. You are going to need to access health services, for example. So someone who has succumbed to gender-based violence has to first find a hospital that can give service. This hospital might not even be where you are residing. These are things that you are doing before you even navigate the justice system itself. So it continues to be a barrier in terms of that. We also have costs related to messenger of court fees. The cost to serve your process, the cost to enforce your judgment, the costs that are related to the court itself. Earlier, I think Advocate Mandinde talked about if you can't find your husband, you can pursue substituted service, so that you can be able to divorce if he's not found. But I want to add it further to say the cost related to that process is not accessible to many. In Harare, just looking at suburbs in Harare, if you are serving divorce process, you are forking out $35 for service. So before you do substituted service, you are trying to serve at the last known address, you've paid $35. Pursuant to that, you are then needing to advertise in a local paper. A local paper is costing you another $30, $40 odd to run that. So when you think about it and say, is this money available? Is it money that is readily available for people to enforce these opportunities that you are talking about? Possibly not, especially if you are thinking about the indigent and the marginalized. If you look at a different process like domestic violence cases where someone is seeking a protection order, one of the things you have to do is to photocopy that those court forms that you are given. The court forms, photocopying them alone will cost you $5. So you are adding that cost to whatever costs you've had. Some people abandon their cases in terms of enforcement of judgment because the costs that are related to enforce that judgment is far beyond reach of many. So costs that are related continue to be a significant barrier. I also want to talk about access to support services that enable survivors of violence to pursue court matters. When domestic violence occurs, one of the things that you might be in need of is a shelter, a place of safety. Where can I go in terms of getting safety? There are 23 shelters in the country. These 23 shelters, the majority of them, 14 of them, are run by Musasa Project, represented here. if you go into the issues that are raised in terms of sustaining a shelter, many of them are underfunded. Many of them are facing closure at the moment because there are no resources to support them. So when we talk about support services that enable someone to be able to pursue the case, these are some of the barriers. You also have services of specialized institutions that promote the issue of access to justice. These services, particularly when we look at the medical services, there are barriers there. If, for example, you look at persons requiring psychiatric evaluations in court for there to be determination, there are psychiatric units that we have are pretty much Harare and Bulawayo alone. So if you're sitting in some other center, your case is not moving any further because you have to access a psychiatric evaluation. But in your location, there is no psychiatrist. At one point in the work we do in Mutare, there were over 80 cases that were totally stuck because people could not find resources to go to Harare to get psychiatric evaluations. So when we are talking about access to justice, these are the lived realities. It's one thing to have the law, it's a whole nother thing to be able to enjoy that right at the end of the day. So how do we ensure that these specialized services that aid a woman's access to justice are made available, are made in a way that allows for people to continue to pursue their cases? And the psychiatric evaluations are just one example that I've picked. There are many. I think to the lawyers in the room, you can think of many examples. The age estimation issues, when the age of someone is in dispute, for there to be assertion of how old is this individual, there must be age estimation. There are complications there. Those services are not necessarily found where people are found. So these are some of these barriers that are there, which mean that we need an integrated approach that addresses some of these barriers that people are facing. I want to talk about gender stereotypes that exist within institutions. When we talk institutions, we talk people. People man the bench, prosecutors, judges, magistrates, and I see many familiar faces in the room. And as people, we come from socialization, we're socialized. We have beliefs, we have values, we have ideologies that we carry. And sometimes these personal beliefs, these values, find their way into the courts. I want to give an example of a case that was dealt with in this country, State versus Ivurino Sara. This particular case was a criminal case. A man was charged with having sex with a young person, contravening Section 70 of the Criminal Code as it then was. Effectively, he had sex with an under 18-year-old girl. He pleaded guilty to the offense. And in sentencing, the magistrate then said, 24 months of imprisonment was the sentence of the magistrate, in which 16 were suspended for 5 years so that the accused does not commit the same offense. The remaining 8 months were suspended on condition that the accused married the complainant. So when we talk stereotypes, we get into these spaces with stereotypes, with beliefs that we have. Fortunately, the judgment was overturned on review in the High Court. But it is an example of how we come into spaces with things that we think are best. In this particular scenario, this magistrate thought marriage of the child who had been sexually abused was the best solution. So we do have cases that talk about gender stereotypes within the court. I notice I have no time, and I will conclude with one other issue to talk about areas where the law is there but it's not working. One of these areas is child marriages. We celebrate the Marriages Act that has criminalized child marriages. But this law at the moment is not working. There are no arrests that have been made using this section. And as we are in this Indaba, we must be asking what is needed to make it work. It's one thing to have the law, but it's another for it to really translate into reality. Another example is the Cyber and Data Protection Act. Last year, during 16 days, we had presentations from the police where women are not making these reports. That's one area where, yes, the law is saying if you succumb to digital forms of violence, you can actually get recourse. But this law has not yet seen arrests around the same. And as we talk, we must be asking, what are those barriers? What is the infrastructure required for us to be able to really see change and see the law working for women? Thank you. Okay. Thank you very much. So when the MC gives you more time, you always smile. But in the more time that has been given, I would be calling the panel. The panel, that is a reflection of work and action that is being done by the different service providers to really breathe life into what more can be done, what are some of the barriers that are faced even within the institutions, what are the recommendations that we can then proffer out of this gathering. So to this end, I would like to call upon the panel, a representative from the Ministry, the Judicial Service Commission. I do not have the panel names, so allow me to just call the institutions without necessarily reflecting on individual names. Thank you very much, Ms. Mtombeni, for representing the JSC, a senior magistrate in the JSC. Thank you very much. I would call the other panelists, maybe they take seats there so that we can manage our time more effectively. Thank you very much. Please, may I call a representative from the National Prosecuting Authority? I see Ms. Chigwedere, a seasoned prosecutor dealing with matters of gender-based violence. I would like to call her. Please, can we welcome her to the panel? Avasat Vashika. I would like to also call a representative from the Zimbabwe Republic Police, representing the police, particularly work around the victim-friendly court, another seasoned practitioner who deals with these matters every day. So thank you to the panel, and I will allow you to talk a bit as you introduce the institution that you represent and its mandate before then getting into the substantive issues. And the session that we are having is interrogating the justice systems, looking at lived realities and experiences for women, particularly framing around what frameworks do we have, what systems are in place, what are the access gaps that are there. So to each, please speak a bit on the mandate of the institution that you represent and then talk to the substantive issues. Thank you very much. We'll start with Ms. Mtombeni.
Thank you very much. I'm here representing the Judicial Service Commission. Maybe you understand it if I say the courts matter ezidosha idaya. Mrs. Mtombeni, the senior regional magistrate at the London Division. I have worked in every part of Zimbabwe, and I actually deal with these cases that we are talking about today. our mandate as Judicial Service Commission is then to, when the cases are brought to us, is to then hear the cases and decide and give judgments. And when there's need for a sentence, give a sentence. When there's no evidence, acquit the person and let the person go back. We actually hold a central position in this judicial processes or in the justice system, because in most of the meetings that we do with other stakeholders, we actually chair these meetings and they are done with us as the central part, because these cases come to us from different directions at different times, and we are the people who will then make decisions, and we are also the people who will then decide what to do with which organization facing what challenges. So you find that our role is really pivotal. That's what I can say in brief. I will go to the challenges, or maybe the introduction that I prepared for this presentation. Access to justice as a fundamental human right includes understanding the judicial system and processes. The judicial system and processes is quite complicated to someone, to an individual, or to someone who is just coming and facing the courts for the first time. Even to some educated people, you just get confused when you get to court. You do not know where to start or how to start, and you need help. So there's need to educate the targeted groups, especially the women and girls, because they are in the dark, and when they come to court, you can actually read as you'll be seated there in that chair that I'm dealing with someone who is actually confused, who does not even appreciate what is happening, but the life of that person is in my hand. Then we're looking at also the utilization of available processes and methods. That is the court attendance, the medical examinations, like was said by Abigail, the expenses involved in the medical examinations and the coming and going out of court, that's something else. And also, I think what is pivotal for women and girls is navigating the whole system from the time they get to court to the time they leave court with their judgment. So you find that there's a lot of education that's needed for this woman, for this girl, to understand what she is expected to do and what she will get out of what she has done at court that day. And then you're also looking at the barriers and how to overcome those barriers. There are so many of the barriers. From morning up to now, we've been talking of barriers, and indeed there are barriers. So this whole system is not about what happens to you at court, but I think it has to do with, it is something that is more than the courts, because it starts outside the courts, it gets into the courts, it gets outside the courts. The challenges that are causing the high acquittal rates or withdrawals, especially of sexual offences, are as follows. Reporting is delayed, leading to loss of vital evidence. So when reporting is delayed and vital evidence is lost, by the time the case gets to court, we do not have enough evidence, and acquittal will result. Poor evidence gathering, overlooking of critical evidence, like the clothes, the statements of the actual first recipient, rape recipient or abuse recipient. Poor evidence gathering is caused by so many things and by so many reasons. Normally when someone is abused, I'm taking an example of rape, and is wearing certain clothes. If she's telling you that he actually pulled my pants and they got torn, he pulled my dresses, and by the time the person gets to report 6 months down the line, that dress is no more, that pen is nowhere to be found. And you ask them, did you take the dress to the police? No. Did you show the police? No. And when the person is, who is being charged is there in court, he's saying, Your Worship, that dress is just a story that's been told. There's no dress to prove that. There's no pen to prove that. And it is actually out out of that evidence that the case was hinged on, and you find that that case can be lost, and then we lose the case. And then interference. Sure. This has to do with the stereotyping that we were talking about. There is so much interference. A child is raped by a relative. You know what they do. If it is my son who raped my young sister's daughter, the whole family, we actually rush behind the perpetrator more than we rush behind the victim, like Abu was saying. So at the end of the day, the child is left alone. And that child to come and then lead evidence in court, the child has lost confidence because she has been interfered with. She has been told a lot of stories. And what happens is, when the child gets to report, most of the cases that we deal with is, if the child is staying with a grandmother, and it is the uncle that raped her, that case, if you don't really go deep, it's a lost case, because the grandmother will be told by the child, Granny, Baba Mimaka after what? Don't ever tell anyone. Granny, and they actually go out of their way. There are cases that we have in court every time. They go out of their way, they get salty, so that the offense is not detected. They do all sorts of things to try and cover up, and by the time the case gets out, there's so much interference, and that child is so scared that she can't even say anything. And do you know what we have actually get to realize now? When a child has been tampered with and has been told so many stories, when they come to court, you ask them, tell us what happened. The child will simply look at you. Did he do it? What happened? I want to go. I want to go to the toilet. Then you can actually tell that the child was tampered with. And then the child tells, the statement is saying, she told the grandmother, and what happens? The grandmother is the one that is coming to court with the child. She said, she never told me anything, because she's protecting her son or a grandson. So it is very difficult. These cases are so many, and it is very difficult to then get evidence out of that child, evidence that will lead to a conviction. So you find that most of the cases are going to be acquittals, because there's so much interference. And the police, the child talks of a different story. That is the original story, because she's told to telling the police officer the truth, because they are afraid of the police. They know that I have to tell the truth. But once the child has been tampered with, she's bringing in a new story. And then when they come to court, that story, the police is on statement, and this is a new story on record. And then which story do we follow? It is very difficult. And we also have some stakeholders. They help in the counseling of these children. When they help in the counseling of the children, they also tell the children their own story. So this child has 3 stories, and the child is coming before me. What do I do? Which story do I believe? What is the truth there? It is difficult. So it is difficult to deal with these cases, especially when we are looking at the interference that is always happening.
Thank you very much. I would allow you a few minutes just to finalize your point.
Thank you very much. And then the cultural and religious inhibitions, I think they were mentioned. Culturally, we as women, we are actually the ones that are actually telling our girls, don't report, what will I do, my marriage. We tend to value our marriages better than our children. So you find that most of the cases are lost because this girl child has no one to support, because this woman is also a victim of losing a marriage. So we still have a long way to go as women. And the safety measures, the access to health care, provide pre and post treatment. We need that, because normally we only have pre and not post treatment. The shelters is another thing. Psychological counseling is also something that is really shouting, because these children and these women, they need to be helped. There is need to train or to teach children and women on consent, and also to promote survivor-centered approach rather than what the society expects or the society is looking at. We have a lot of referral issues. We're talking of referral fatigue. We have one-stop shop centers like the Epworth one, but unfortunately we only have one. We need to have a lot of those, maybe in almost every province. And the issue of the course, the DNA is a very, very shouting issue. Not many women and children will afford the DNA testing. And this is what is going to cause a lot of dragging of the cases, because we will be waiting for government to then provide testing, but there's no testing. We actually pray and ask that if it was possible, we would then urge the interested or the stakeholders, the government, to have DNA labs in every province, so that at least it is decentralized, and then we do not have a system where we only rely on NAST, that is the one that is working now. It is very difficult, and most of the cases, especially from those living with a disability, are very difficult to prove unless we have conclusive DNA evidence. So that's another thing. We also pray that maybe we have an increase of the facilities like the UN market network, because it empowers the women to then manage to find money to go to the hospital with the children, to go to courts. And the issue of age estimates is another shouting issue. So we're thinking that it would be best if we can include or co-opt the registrar's office into those services, or into the one-stop shop, so that when they deal with the children, they give them the registration and the children have identities, so that at least when we are done with the case, the child has something else to hold on to, and the child is known as someone who's been registered. We also, I can see she's coming to tell me to you. Complaints and feedback. We have M&E reports that we do as Judicial Service Commission to help us that. We also hold VFC meetings and stakeholder involvement to get feedback. And we also have an open door policy where we do deal with complaints that are brought to us. And currently we have what is called client satisfaction survey that is done by an independent person. We also have suggestion boxes and help desks at courts like beside. I think basically we should have that, but we still have a long way to go, especially the women and girls. We need to support these groups. Thank you.
Thank you very much for that presentation. I think we have been taking notes. We'll move over to the National Prosecuting Authority. Maichi Gwedere, you have 5 minutes to speak to your presentation. Thank you very much.
Thank you, Abby. The National Prosecuting Authority is mandated to prosecute cases on behalf of the state. In simple terms, we as state lawyers will bring criminal cases before the court. And at law, we have only one prosecutor, that is the Prosecutor General, and all other prosecutors are but representatives of the Prosecutor General. So our role is to prosecute cases, criminal cases. Our mandate is for criminal cases. So in our line of work, we are closely connected with the police, because the police do the investigations, they compile the docket, then they bring it to us for further management. So we see the starting of the referral system, that is the police bringing the case to the police, to the prosecution. So when cases are brought to our office as prosecution, we have what we call a sit-down office. And for women and girls, we have a specialized sit-down office for VFU, where we are saying we have specialized officers who receive the survivors and interview them and manage their cases and refer them to the appropriate cases. So there is the issue of safety of the survivors. I would want to say, to my understanding, the safety of the survivors starts from the police. The minute they get to the police, they are received in the VFU, specialized unit, the VFU, and again, when the baton is passed to our office, we also have a specialized unit that deals with vulnerable witnesses, Why do we have withdrawals and also acquittals? That's the question, that's the general question we have. But we are saying the legal process, that is the prosecution of a case. Remember, we have to balance the rights of the accused and those of the witness. And it's about the truth, what really happened. It's not what is written in the docket only, but what is presented in court. In practice, you find that at times we have a very good case on docket, but when we get to court, the witness will tell you a totally different case. In practice, one of my experiences as a prosecutor is I led a 5-year-old, and she was excellent as a witness. My last question to her is, has anyone told you to tell us something? Then she says yes. Then who? My neighbor. What did she tell you to tell us? She told me to lie to you that Baba Mini raped me. But the docket is clear that we have a case of rape. But that single statement changed everything. So these are the lived realities. But by those who are not in court will be wondering, then they see a docket coming with an acquittal. What has happened in court? You know, there are a lot of theories. So what I would urge the House is get time to get to court and listen to what exactly happens in court. Then you learn to know and understand the realities of the court processes. We also have cases where one of my cases was it was discussed on radio. For some reason it was discussed on radio. I put my witness on the witness stand. She testifies. Cross-examination. Confirm you were on radio on such and such a day. Yes. Confirm the story that you told us today is different from the one that you told the nation on radio. Yes. Then I'm done as the prosecutor. We have 2 different cases. And the versions were totally different. So what am I saying? I'm saying the manner the cases are handled along the way. I would say maybe we have pollution of evidence along the referral system. Where we are saying Mrs. Mtobeni has also highlighted it, where we are saying as they interact with organization X or with Mrs. Y, along the way they are told. For example, when I get a 5-year-old, I don't expect them to come and tell me that they were raped. There's no way a 4-year-old or 5-year-old will know what rape is. They should simply tell me that X took his Y thing and put it on my thing. That's the natural language for that age. But along the way, the evidence gets polluted, and then they are told, what happened to you is rape. So the minute you try to lead evidence, what happened? I was raped. Tell us what happened. I was raped. Was someone along the way told them that you were raped? But it is only the court that has to pronounce that whatever happened constitutes a rape. So I would urge stakeholders that as we interact with the survivors along the way in the referral system, let's avoid tampering with evidence or let's give us the witnesses in their natural form. Then we'll do our best from there. But the minute you try and explain, you give them, like Mrs. Ntombeni was saying, you also give them what has also happened to you and what, by the end of the day, they're so confused. But they are confused before the crucial point. Because it's not about making the report. It's not about the good docket. What matters is what they tell us in court. This is what is on record. This is what is crucial. So let's have the witnesses in their natural form. So I think Mrs. Ntombeni has done justice to the referral system as well. And I've also noted that we have these barriers that we're talking about that affect the women and girls. And one of the challenges we face in practice is the women and girls are not empowered. The rape has occurred within the home and by the breadwinner. but behind the back, the social issues are affecting them. And unfortunately, usually they just get support during the duration of the prosecution. What happens to them post testifying? What happens? Because it's not about today, it's not about the date of testifying, but there's a life after hearing the case in court. What happens with the survivors? Where do they go? Who looks after them? I'll put that to the house. And maybe it's one of the things we need to also to look at. Then also have the laws. Abigail is appointed our very good laws and practice. But some of them, they're not really, when you prosecute a case or when you're in court, you can tell the limitations of the law. For example, with the new Marriages Act, which is criminalizing child marriage. But why are we not getting the cases? If you really look at it at the law as it is now, you find that it really creates a very wide platform for prosecution. But who are supposed to be the witnesses? Panororo Wamana, who is there? The mother, the tete, the wife, and all of them, in terms of the law, they're supposed to be accused persons. Who can testify against family? Who can testify against the tete? Yet they were all involved in that. So maybe we need to look beyond that and say, maybe how best can we prosecute these cases, or what evidence can be acceptable? One, or maybe we would say, once we see a child staying with a man, what's the even the definition of marriage? But this is not marriage, it's abuse. How can you talk of child marriage? It's child abuse. But it's all those things. So there are lots of things that need to be looked at, and also that would also assist us. Then we also have mechanisms like Mrs. Utopia highlighted of dealing with complaints and feedback mechanisms. We have the monthly multi-sectoral meetings that are done. Then as NPA, at national level, we have a monitoring and evaluation and inspectorate department that is there to look into any issues or complaints. So if you have any complaints, you can approach that desk. They will definitely assist you. Then at station level, allow me to say, you don't have to wait to come to the head office or the national desk of complaints. At every court, criminal court, we have a prosecutor who is in charge of that station. They are equipped to deal or help you with any complaints that might arise concerning your case before the court. And they will also explain if the need arises. So in a nutshell, I think that's what happens. So among other things, I would recommend some legal reforms. I'm concerned, for example, with the definition of vulnerability. Yes, it is section 319B has been expanded, but we still have some areas which in practice really affect. We've talked about the cultural and religious. Doesn't that make someone vulnerable? But it's not there in our laws. It's just food for thought. It's some of those things maybe that need to be looked into. Then we also have the procedural challenges. Remember, when you go to court, we have two parties, the accused and the complainant. And the accused also has their rights. At times, we have a case, we have review proceedings with constitutional applications. We suspend the hearing of the trial. And you know what I'm talking about. Maybe the witness has traveled, the witness along the way, then cases are making headline, and it's also one of the barriers. So maybe those are the practices. If maybe we could come up maybe with magistrate court rules, which specify at what stage and when we can hear cases, or before all other issues can be dealt with before a trial date has been set. Then we also have prescription of cases. In Zimbabwe, only major cases can be prescribed. But if you look it's a vulnerable with persons. Just last week I was dealing with a case that happened in 2008, and for some reason she decided to report now. Fortunately for us, it's still within the comment time, but at times we receive cases after 20 years, and we cannot hear that. But maybe the survivor has a very good reason why she has decided to come. So maybe it's good for that again on the issue of prescription of SGBV cases. Thank you.
Thank you very much, Ms. Chigwedere. On that prescription note, your time had prescribed. We will hear the last presentation from our victim-friendly court, the Provincial Victim-Friendly Unit Officer, Ms. Kanyemba. You have 5 minutes, Madam. Thank you.
Thank you. All protocols are observed. As a therapy, our mandate is enshrined in the Constitution, is to investigate, detect, arrest, maintain law and order, protect life and property, and many other things. As a therapy, we found that it was very difficult for women and girls to come in the charge of send report that I was raped. So in 1995, they decided to form a section which is called Victim-Friendly Unit, where there are trained personnel to do with the HBV cases. How does the VFU align cases management and service delivery in the national framework? As victim-friendly unit, as police, we don't work alone. We investigate, detect, but we don't prosecute. We deal with other stakeholders. That's multi-sectoral approach. We receive cases at the station, so we encourage everyone when coming to the police station, you ask, I want to report a case to the victim-friendly unit for safety and secretly tell your story so that there's no shaming or stereotyping in the judge office. Then at each and every police station there is a victim-friendly unit section. Every police station in the whole country. So you just get in the judge office, you say, I want to report my case to the victim-friendly unit, and they will help you. They will not ask you any further questions. You just go to the victim-friendly unit and report your case. Gaps which are there, the police office, the staff turnover due to transfers and retirement. So you find that there are few victim-friendly unit officers at police station, but I assure you will get help with that shortage. There's shortage of resources, e.g. transport to fed survivors from one point to another, seeking for services. Shortage of shelter. Someone is in a domestic violence, the husband is promising to kill him or the wife. She came to the police station and she says, the husband wants to kill me, but we don't have shelters. We don't have safe houses at the police station to place the victims. The victims, they come as little as 2 years old. There's need for them to have food. There's shortage of foodstuffs to give those survivors and their accompanying guidance, resulting in the investigating officers pumping out their own money for transport and food for those survivors. These are the gaps which are facing the victim-friendly officers. On how accessible are VFU services for women in rural and remote areas, and how do transport barriers, police stations, locations, and infrastructure constraints affect reporting and service uptake. VFU services are accessible throughout the country with a VFU office at every police station in Zimbabwe. The challenges: survivors face long distances to police stations, no transport fares, no standalone VFU offices. We have some of the stations we share the VFU offices with other offices. So every time you end up, you might go outside and have an interview, or ask the other office to go out so that you carry out your interview. And this is a challenge which we face in other police stations. So for the confidentiality, it may lead someone hesitating to say the story. At our police stations, we don't have ramps, and that makes it difficult for survivors on wheelchair or those survivors living with disability. And we also face there are no internet connections for investigations of online cases. Most of our cases, they start online, then end up in a physical. So there are no internet connectivity. Going to what is the step-by-step pathway from reporting to the investigation, referral, and court process in VFU supported cases, and what are the average timelines for GBV cases? We use a multi-sectoral approach. Fresh cases are referred to hospital for treatment and medical examination before investigations. When we say fresh cases, these are the cases which had happened within, we say we should report within 72 hours so that we refer you to the health services for examination and extraction of the evidence from your board, because in cases of sexual cases, because some of the survivors, they cannot say out what happened, and we are talking of intellectual survivors, so that evidence of DNA is very important. We refer to the hospital for examination, and the evidence is extracted from the victim. We take it to the forensic lab, and with this 48 rule, where both survivor and suspect are available, when the suspect is available, the docket just takes 48 hours to be completed, so we refer to the prosecution. Pathway. Police, our duty is receiving the report and investigating. We have health, they do the examination and treatment, because SAFET first, the survivor should be treated before anything. We have the DSD for counseling and being support persons, and for probation officers report. NGOs, they support us with counseling, shelter, and like Msasa for domestic violence cases, we refer the survivors for temporary shelter. We have the GSD when there are children to prosecute the case and sentencing of the accused. Which legal policy and operational funds are most needed for strengthening the VF use effectiveness, and what practical changes would most improve survivors' access to justice? Key laws, we have the Criminal Law Codification and Reform Act, we have the CP and Act, we have the Domestic Violence Act, we have the Termination of Pregnancy Act, we have the Cyber and Data Protection Act. Maybe on Termination of Pregnancy Act, some may say, is it allowed? When the person is raped, we have 3 incidents which termination of pregnancy is allowed. When the person is being raped, was raped, when there is incest, relationship between people are related, then when the pregnant is danger to the life of the person. Then the practical changes, we are now a fast tracking of cases by the courts. When every evidence, if the accused is there, every evidence is there, they are doing fast track cases. They just take 3 days to finish the case. How does the VFU collaborate with the health services, social welfare, NGOs, and the prosecutors, courts, where to coordination breakdowns okay? Collaboration through the multi-sectoral approach, e.g. we carry out the victim of the VF system, the victim-friendly courts meetings every month, where we gather all stakeholders, we talk about our cases, our challenges, what is needed, social welfare, referral for shelter and counseling, NGOs, for example, Msasa, adult rep clinic, childline UNICEF, counseling shelter, and they help us with the workshop. We do workshops with them in training of the victim-friendly unit investigating officers, because there's need of training victim-friendly officers how to handle victims of GBV. Coordination breakdown. The long distance between stakeholders. For example, 72-hour rule for fresh gender-based cases where PEP is needed. You see, like in rural areas, the person is raped, maybe she gets the courage to talk about it. After 24 hours, they come to the police to report. The police is far away from the hospital. There's need to go with the survivor to the hospital, because when it is a fresh case, we need to carry the safe kit so that we gather our evidence. Then from the hospital, we do the investigations. The court will be far away from the police station. We need again to take the survivor from the police station to the court. So you see, it's a big barrier, which is there's need of transport cost, funds will be needed, food and everything. And the 72-hour rule, we encourage the survivor not to bath, but how many days is she taking without bathing so that the evidence is being retrieved? It's another barrier which is there. No transport to ferry survivor from one stakeholder to another. delay in response by service providers like Econet and like online cases. We are really facing a challenge because you should apply to the Econet a warrant to search and seize the gadget. We need the information. They relax to give us the information. We get it with much, maybe they will reply you after 3 months and they will say there's nothing in our database. That's the other challenge we are facing. What we are saying is let's work together to protect our women and girls against gender-based violence. Thank you.
Thank you very much to our panelists. Thank you very much for sharing those pointers. I'm sure at some point we will have plenary. Oh, okay.
I saw you say to everyone that if you're sleeping, we can see you on the screen.
Thank you very much. So we'll open up plenary, and it is what is standing between us and lunchtime. So can we be very precise, direct our questions, or engage on the issues that we've had all morning in regards to what are some of the barriers and challenges around access to justice? There is a roving mic, so if I can acknowledge the first few individuals who want to make comments, questions, or additions to the discussion. I don't see a hand. Is it that we're hungry? Thank you.
Good afternoon, ladies and gentlemen. It's been a long morning listening to all the presentations.
My apologies, sir. May you please start by introducing yourself, your organization that you represent?
My apologies. My name is Mertha Nyamande. I am the director of Insight Wellbeing. We are psychology and mental health solutions. So having listened to a lot of what the presenters have put across, I think there's one thing that stands out the most. I think from every presenter, they've talked about the issue to do with resources. Now, I think whenever we get to a point where we can't get a victim to a police station, the police are asking for money for something to be done in terms of bringing in the perpetrator. I think these are the things that get in the way of the justice that we are trying to get to. However, from a psychological point of view, which we deal with on a regular basis, there is a lot that is missing from our cases. We talk about the medical side of things. Now, medical is very important, but it's missing the other part of what health looks like. Health is not just medical. Health is also psychological. It is also social. So these are the things that are missing. I think even when courts are sitting, they make a decision based on very limited information. I think when we look at the biopsychosocial model, we're looking at the courts just focusing on the bio and overlook the psycho and social elements. Now, especially when we're looking at these serious cases to do with SGBV, these are very serious and very sensitive cases. And there's a serious psychological impact on, one, the victim and the accused as well. Because whilst you're waiting to be judged, sentenced. All that time, you may be waiting 2 years, 3 years, or however long that takes. That is a significant toll on the mind of the accused. It has a significant toll on the mind of the victim. So we need to be very sensitive about what is it that's going on as far as the support systems are concerned. Now, I also want to highlight the element of what we call forensic psychology. Now, this is a new aspect in our justice system. It's a new field that's being trained at the University of Zimbabwe. That's what I'm aware of at the moment. I'm not sure if there's any other universities that are training it. But when we start to look at the element of forensic psychology, we're looking at those elements that I've just mentioned that tend to get overlooked. Why and how did we get here? Why and how did this person commit this offense? What's this person's background? And what are the risk factors? So these are some of the comments that I wanted to point out and to invite our institutions, especially the Judiciary Services Commission, to invite more expert witnesses, especially when it comes to the psychological and the mental health elements. Mental health is not only that person who's talking to himself, but there are almost 300 different diagnoses in the manuals. So we need to be mindful of all those. Thank you.
Thank you very much. Thank you very much. All right. I'm going to give you, because of our time, I'm going to give you a 2-minute response. Please stand your seat. Have you got a microphone? I'm happy to meet you. I read about you and also thank you. Wherever you meet you here, I don't meet you here.
Yeah, you want to definitely not meet me. Thank you very much for that. We actually have moved a step further as the Judicial Services Commission. Now when we are dealing with cases, when we are doing the sentencing part, we have where we use what is called the victim impact statement. They cover issues like the psychological trauma, the harm, and all these other, the economical, whatever, effects of the offense. So this is also considered. And also, where we are dealing with a case, maybe I'll just give an example of a case that I dealt with, that we had a lot of psychological issues to deal with. The old mutual case. We used a lot of information from the doctors. So from experts, I think I had more than 5 expert witnesses in that case to try and prove certain points. So we really need, we really use a lot of those expert witnesses whenever it is necessary. But if it is someone who is not defended and the person cannot afford, normally it is very difficult because there's no person to then fork out that money for the person. A similar case will be the case that I dealt with, the case of that child who raped a child at Rizende. It took us maybe 6 months to complete that case. Why? Because we were moving from one government department to the other, trying to get assistance to have that accused person examined. But still, he was not examined until the last point. So you find that we really need the expert evidence and we use them. But what is also the challenge is, like we said, the resources.
Thank you very much. Another question? I'll take 2 more now. Another question? Another question? Yes.
So I don't know, it's worth reflecting. I've learned in Zambia, they have done away with bail for accused persons facing charges of indecent assault, rape, etc. I don't know, would this be something that we want to consider? Of course, I understand the presumption of innocence, but I'm really keen to know whether you have followed the development and how they're doing it.
Thank you. Thank you very much.
All right, thank you. I read and I was still debating with my colleagues on what's the way forward, on whether that is the best practice. Look, there are issues of rights. The accused has rights, the victim has rights. And we as a nation, we must be seen to be doing what is fair and just. So it is the way you look at it, what is fair and just, also considering the fact that the person can be an accused person but wrongly accused. And we have already logged the person in. There are repercussions. And this is an innocent person suffering. Or the person, there are so many issues that come into play. We are still debating on that. Whilst it may look very pleasing, but there is the other side that we are not looking at, that we must also consider. Yes, just like we were saying, we want these people convicted, but we cannot convict where there's no evidence, and we cannot convict innocent people. So that is, there must be a line drawn between the two. So while to some it is a positive move, to others a negative move, we need to think deeper.
Thank you very much. Thank you very much. Very insightful right there. Very, very insightful right there. I loved how you said that. I was looking at it with other colleagues, just to reflect and look at how beneficial it is for our justice system. Thank you very much for that. Yes, ma'am.
Thank you very much, moderator. Mine, I don't think it's a question, but maybe it's a contribution. Maybe as Parliament, our duty is to represent, legislate, play an oversight role. The law is written, but is it implemented? We have Vanilla 9 years, 12 years, and we are saying, what are we doing? Where are we losing this? Because why can't we all come under one roof? So that can a case rep ikauya. What's the justice ikava, shikava, pasoma, shatombolon, zingash, mayam, jiri sort of like she put on a one-stop center. So that justice iuye kumwana. Imagine unogara sei uine kana kuti nyange ndachemera saizvozvi ndine nhumbu yavarume chikoindi vakadhirepa vandisingazivi, but because justice is delayed ndichazvara mwana iyeye. Mwana iyeye handifi ndakamupa rudo, ndatove kuzotonopara imwe crime yandichaita because mwana uyu ndogona kugara ndakamuvenga mupa marelations angu anomuvenga, whether another husband achamuvenga because ana kuuya nenzira kwacho. Tinokuti isusu, why can't we come nesituation yekuti zvinhu zvingoitwa chokuchoku inoda kusienda kwaino mutemo handizivi kuti tingautanga sei kuparliament, wekuti kana munhu akasvika pakuti asvike pakuzonogara nechinhu chakadaro, ini mutemo wacho uripo nelaw yacho iripo. I think something has to be done kuvanoimplementa mutemo iyoyo. Then chozoya kuti also kuparliament tofunga tinofunga kualigna malaws edu, because tiri kuti a child is under 18 but sex anogona kuaccess at 16. Saka izvozvo zvinoda kuti zvialignwe, because kokanaita sex kaanofanwa kutoroorwa, but muri kuti child again. Saka I think these laws again tinofanwa kuti tione tobatsirana sei kuti mitemo iti align kuti igone kumira zvakanaka, because zvimwe zvacho zvinopoinda fingers back to us. Saka ndandichingoreva kuti ndoda kutsigira vambotaura kuti mitemo yacho iripo, but is it being implemented in time? Thank you.
Thank you so much, and very interesting that you should mention the issue of a woman who is raped. I think that I would like to refer to my brother at the back there, who then also alluded to the issue of mental health. During that period of being raped by, in the example that you've given, 20 men, and even after giving birth to that child, a very relevant point right there. So you're looking at it from a legal perspective, but also from a mental health perspective, because there are a lot of things that need to be conditioned there. Please go ahead, respond.
Thank you. Allow me to comment to what the Honorable Lady was talking about. Maybe we should also consider that access to justice is not only about what happens in court. It's what happens in the community. When you find a 9-year-old giving birth, it's not about the justice delivery system per se. It's about the community. Where was the child? Why was the matter not reported? Because we have mechanisms where we, for example, if we have a 9-year-old who is pregnant, there's provision for termination of pregnancy. But because they present late, they don't have access, because at times they present when it's no longer possible to terminate that pregnancy. So there are a lot of issues. Whilst we look at the service providers, but we should also look at, along the referral system, at what stage are we getting are the cases entering the system? Most of them, they enter the system very late. And at that stage, we just now see the child, and at times we blame the system. But the community is one of the key stakeholders where maybe we should also emphasize, where we are saying even in testifying, a child would testify that I was raped and I told my Peter. My Peter comes on the witness stand, she will tell you, and you receive. And then we lose the case maybe on that basis, where we are saying maybe the child is fabricating a case. So we are saying, whilst we deal with access to justice, looking at the service providers, we should also pay attention to the role of the community. Remember, the community, that's where the accused is coming from. That's where the witnesses are coming from. That's where the offenses take place. And if the cases are not managed well within that, we inherit now a case that has already been, tempered with at community level. And we try, but at times it's with difficult. So those are some of the challenges that we encounter.
Thank you very much. Thank you very much. I'll take my last question. Sorry, allow me to just talk to the gentleman there. I'll come back.
Mazita, ndotwa Chief Chisunga. Ndandine mubvunzo panapo wekuti ndinonzwa pane nyaya dzekuti pane mari dzinopiwa ma-witness like for transportation. Asi mari idzodzo tikazvitarisa ndofunga wakawanda hatizvizive. Like kwedu kwatinobva kumamisha kuti we travel long distance kusvika kupi kumakotsi ikoko. So vanhu vakawanda vanogumisira vasaripoti nyaya nokuti anenge achizoti mangwana ndikadzi witness auye, because mukatarisa zvakare kuti makotsi mapostsmen enyaya akawandisa kuti nhasi nyaya yauya mumanzano munozoya next week. So witness ndiye anenge akuita se anenge akubhadhara mari dzetransport kuenda kukoti kwacho nezvese zvezvichidiwa. So ndiri kuti inini handizoti vanhu vangaziva sei kuti mari idzodzo dziriko, and also kana tasvika kukoti kwacho vangatikwanisa kutiudzawo here kuti mari idzo dziripo, so that it encourages people to report macases iwayo.
Can I answer here? Sorry. Okay. The issue of witness expenses, Mambo, thank you so much for asking. One thing that I've found is really very effective. Kana imumi vana mambo mukasangana nevamwe vana mambo venyu vaudzei vaende kumisangano every regional court, and in every district we have a regional court kunoitwa vanonzi ma-victim friendly meetings. Zvese izvi zvinotaurwa, and vana mambo veko vanotozviziva kuti kune vanhu vanopiwa, kune chinhu chinopiwa vanhu chinonzi ma-witness expenses. So ndozvekuzoti ivo vana mambo vagere padare pavo vanogona kutaura vachiudza vanhu. And also Judicial Service Commission in a very good relationship. Panga vakatarisa TV kuswera nezuro, I think that was Monday, the head of the Judicial Service Commission vakatoinda kwamambo kuruzevha chaiko vakanopinda mudare ramambo, and paradza pane ukama. Vana mambo kana mane matare yenyu musi wamune dare renyu dedzai magistrate ari pa next station azoudza vanhu zvinoitwa kukoti ndopanobuda unyedzi kuti anogona kuvadzidzisa nezvekuti kana muchizenge maitirwa nyaya munouya kukoti munokwereta mari kuna neighbor wenyu kana kuti munotengesa huku mosvika kukoti mapedza kutongerwa nyaya yenyu vaudzei vamuchuchisi ndiro gweta renyu kuti ini handina mari yebhasi in case anogona kukanganwa mobva matopiwa mari dzenyu dzemabhasi endi zvatinoita nemawitness expenses mukauya nhasi mambo kesi yenyu ikarega kupinda munosainirwa yatinoti sapina ndizvo maichigwedera and then modzoka next time kesi yenyu yopinda toitonga zuva rodoka moenda modzoka all those times dzamunouya munopiwa mawitness expenses enyu kana kuti mukatouya musiwo zvichinzi hapana mari musi wamunodzoka next time munouya muchitopiwa mari the previous attendance yamakaita saka zvinongoda kuti tite ma-awareness campaigns kuvanhu vedu especially muvana mambo because ndikumatova ma-key stakeholders munyaya yejustice because you are the original courts kumareserva uko ende ndiko kunobva hama dzedu nevanhu vedu vanoda this witness expenses it is something that is real and that is there but iwo ndo musenzekete wanda kutokuisai pamafudze mambo monoudza vamwe vana mambo tine a lot of vana mambo vanonyatsozviziva like when I was in Chief, I was working with Chief Nyoka, Chief Tekeza, Chief Chivese, Chief. There's so many chiefs who are very live to these issues. Even when I went to Mtobo, because it's one of the stations under me, child marriage, I was so impressed. So you find that you are the stakeholders who are supposed to bring this information to your jurisdictions. Marita Mambo.
Okay, good afternoon, everyone. My question is directed to the Judiciary Service Commission. I want to know what the JSC is doing in terms of decentralization of services, especially concerning the outlying districts in our country, where we don't have access to the regional magistrates. I think we can use we could utilize the model where we have the High Court being decentralized to different areas. I think that model could also be used in terms of the regional magistrates, so that maybe we can access those services in our districts.
Thank you very much. We actually have more regional courts than high courts in Zimbabwe. And we also have ma circuit courts, ma regional circuit courts. Ekuti regional court inonogara pane imwe nzvimbo votonzwa ma cases vodzokera vachiseterwa down at different dates dzinenge dzakaitwa dzakarongwa kare. We actually have a lot of ma regional courts in almost every district now. We have a regional court. It's just that togona kunge one, but we have regional courts in almost every district now. And the Judicial Service Commission is still expanding on that. Vachiri kuvaka matare and vachiri kupinza vanhu basa vanozoita ma-regional magistrates. But you find that even mukatarisa kwakaita sokudana Mutoko chaiko kana pana mambo babva kwaMutoko maybe mogona kutondivitnesera kuti there is the regional court there. Mukatarisa kunana Guruve where you think kuti kure chaiko there is the regional court there. Mukatarisa kunana Binga we have a regional court at Wange. We have done we have really tried our best to be there. Although we are moving towards there, but we have regional courts in almost every district.
Good afternoon, everyone. My name is Ruth Chibwe from Zimbabwe Lawyers for Human Rights, or ZLHR. Thank you also for this Indaba and every other stakeholder here present. So, during our rural communities visits, we visited Kuma border, where Zimbabwe, Mozambique, Zambia borders meets far in the rural areas. You know what? The communities have actually agreed, they've actually embraced the child marriages. The children are marrying each other there.
They actually do a mutambo. There's this real community where we had a mobile legal clinic. They actually do a mutambo where children are marrying each other, and they actually provide everything. They're actually making these child marriages appetizing. They actually give them everything to start a home. Underage children are marrying each other. The other issue here is the law exists. The enforcement does not exist. Does enforcement start and end with, say, the police only? Or it starts and ends with the neighbor who's seeing the child being married off? The teacher who's realizing that the child is no longer coming to school? Or the doctor and the nurse who delivers the baby? Or the man of the cloth who realize that the children are no longer coming to church? Or the men of the cloth are the perpetrators? Or the teachers are the perpetrators? Or the neighbor is the perpetrator? Or the parent is the perpetrator? So who's going to serve these children? We've realized that girls are removed from school to be married, with parents telling us that they have no choice because of poverty. Families where the perpetrator often are older men with money, and community status has successfully pressured the family to accept the marriage and stay quiet. Community members who know what is happening but are too afraid or too economically dependent on the perpetrator to report. Girls who are pregnant at 13, 14, delivered at clinics and hospitals and discharged without a single report being made to the police or child protection authority. So my recommendation is, why not involve the nurses, midwives and doctors? Why, by making them mandatorily report these legal challenges. Nurses, midwives and doctors who deliver underage pregnant girls or treat injuries consistent with child marriages must be legally required to report this to relevant authorities as a professional obligation backed by law. Currently, this is not happening. Girls are being delivered and discharged as if the pregnancy itself is unremarkable. Health workers should be trained, protected from retaliation when they report, and held accountable when they fail to do so. Thank you so much.
Thank you very much. And I'm going to ask you to respond briefly because of our time. Just 1 minute, please.
Thank you very much. That's a good recommendation, but it starts with the community, like she said, and we only know of it when it is now brought to court. So it must start there, and reporting must be there. Like the GBV, payakanya kunge yanetsa. Mapurisa, they were told that you don't, sorry, my nurses, you don't treat anyone akakuvara as na police report. It was very effective, and it is actually helping bring out those cases. So we can do as well the same thing. Kuti hamubetserisi mwana ni 9 months, but the challenge is anonoberetsesorwa kwana mkuta nyamkuta, where and then the nyamkutas are given mombe. They vono drivanza, and at the end you only find the child as a child when she's also a child.
Yes, I just wanted to add that I think there was a research that was done along that around Bridge, and it was clear that the minute they know that such a clinic will report, they won't go there. So it's now a balance where the nurses were saying it's better that maybe we treat them, then maybe you find ways. They can just maybe be whistleblowers or something. But as long as they know that if you go to the clinic, the husband in courts is going to be arrested, they won't go. So we're going to also have high mortality. So it's a very tricky one.
So clearly it's important for the community to be hands-on. I think justice begins with the community. We're going to finish off this part of our interactions by saying that justice begins with the community. Thank you very much. Would like to give a round of applause to our panelists, to appreciate them. Thank you so much for the presentations, and also thank you for your responses, and thank you for sharing information which is critical. Ladies and gentlemen, we are now going to break for our lunch. We have given or issued out our meal tickets. For those with meal tickets, may you kindly leave or exit and go to the buffet setup that is outside. And then as soon as those with the meal tickets leave, the others may join in. You're going to receive your meal ticket right at the door. We are back at exactly 2:15. 2:15, our panelists will be ready and our facilitators will be ready and on standby. Thank you very much. Good afternoon.